The Accelerator Podcast is here. I'm your host on tap, Monty King, inviting you to leave ordinary in the dust. Every next level of our lives demands a better version of ourselves. Our guest will inspire you to close the gap. What doesn't happen by design happens by default, so the content on tap is created for listeners to learn and grow. Visit us online at whatsontap.tv or find us on your favorite podcast platform. If you're listening on Apple Podcasts, tap 5 stars and drop us a review. Hit the notification bell to never miss an episode and share your favorites to help others outrun the status quo. Let's get started. I'm excited to have Dr. Bill Kanasky on tap today. Bill is Senior Vice President of Litigation Psychology for Courtroom Sciences Inc., a nationally recognized expert, author, speaker in the areas of advanced witness training and jury psychology in civil litigation. The disturbing trend in the transportation industry is the increase of frequency and severity from nuclear verdicts and settlements. And Bill is restoring the balance to the scales of justice by attacking the reptile theory with the mongoose method. And his outcomes from his work are sending shockwaves through the country. And we are honored to have Bill as our guest today. Bill, welcome to the show.
Thank you so much. I am a disruptor of the system. That's my job. And I love disrupting, and it's going really well.
Yeah, I was about to say, you're doing a pretty good job attracting a lot of attention, I guess is the right way to put it. So, as we dive in, what I really like to do was get a little bit into your backstory before we get to today. So walk us through a little bit on, how we got to the mongoose method, I guess, is the high level end result. But take me back to your early days. When you first kind of realized that you could make an impact and how your passion started for what you're doing right now.
Yeah, sure. In the early days, 20 years ago, it's my 20th year. Those first 3 years, trials were very common. And everything I was doing was a form of trial preparation. It was very different than it is today. There's so many settlements today. I believe it's 98.5% of cases settle. Well, back in the year, 2001, 2002, 2003, in the early 2000s, there were a lot more trials. And so I was constantly preparing clients for trial. And after doing that for a few years, what I had realized after going through deposition testimony, deposition transcripts, deposition videos, was that a lot of the outcome at trial was really dependent upon how things went in the discovery process. So I was finding that, really bad deposition testimonies coming back to haunt these clients with the jury, at trial. And a lot of the trial, lopsided, unfortunately, right? Lopsided results in favor of the plaintiff. I would often get called, I wouldn't work on those. I get called afterwards, and they would give me the list of jurors or contact information. So I was starting to break down nuclear verdicts 20 years ago by actually talking to the actual jurors on the jury. And as part of my, roughly 1 hour and 15-minute interviews with them, we'd go over the key factors that were driving their decision-making to side with the plaintiff and then to award high damages. And so many of these had to do with the quality of the witness testimony from the defense fact witnesses, from their corporate representatives, their safety directors, the key fact witnesses, boots on the ground types of people. And I was seeing how important that was into jury decision making. And then when I got about 5 years into it, I started telling clients, hey, wait a second, if all these problems are happening in discovery, right, and these depositions are so bad, and then you're having to take that testimony and take it to trial, this is really a losing formula. Why not let me fix these witnesses before the deposition So then you have quality testimony. So if and when you do get to trial, it's not going to be used against you, and you're going to have so much more leverage. And clients bought into that system. So that's about 15 years ago. And, just so much success with that kind of general system of early intervention leads to better outcomes. And that's where my passion really started, because I started doing things a lot differently than my colleagues or my competitors, and getting in, rather than on the back end of cases, getting in very, very early and doing a lot of damage to our enemy, right? Plaintiff's bar, and being able to get my clients to help them attain better, fairer, more affordable settlements, and then going to trial and winning, which was fantastic. And then 2009 came, and that's when the reptile theory was born. And that was kind of a nuclear bomb in itself, which led to an even more aggressive plan by me, which you heard about in the talk that you saw me give in Nashville.
Yeah, it's all that's awesome, and it makes a lot of sense considering the training that you gave us a couple of months ago. But and is that what triggered your passion to put an end to the reptile theory? So all that happened, and you saw that there was a process, and I'm assuming because you seem very process oriented, right? One thing leads to the next, and it kind of builds up to get to the result. So you were actually doing the process, then the reptile theory hits, and then something lit a fire underneath you to really attack that, right?
Oh yeah. So in the first 2 years of let's say 2009 to like 2011, 2012, no one really knew what reptile was. No one knew how to deal with it. It was very new. So it took a couple of years, 2 or 3 years, to start to figure out, okay, what the hell is going on here? And they kept the secret as long as they could. And then word started to spread. And so I saw this, and by the way, hats off to the plaintiff's bar and the reptile theory folks. I mean, they've been tremendously successful. They created a very, very effective system that the defense bar was not ready for, and did a really good job and continue to do that. Things have changed. We'll talk about that. But when I saw that system and I was able to get my hands around it, break it down, I reviewed hundreds of deposition testimony transcripts from reptile attorneys, and broke them down to the molecule, okay, and was able to crack the code on what they were doing, the reptile attorneys were doing with the witnesses. And then also within that time frame, I was able to review and actually sit in on actual trials, and read trial transcripts, sit in on trials where I saw the reptile theory playing out. So again, I broke that process down. Then I accidentally got my hands on the reptile training materials, which was gold, struck gold. So then I physically had their blueprint, what they were doing. So I was able to break that down to the molecule and essentially build a system to defeat it. And it's been wildly successful. But I'm a scientist. I'm a PhD scientist. I'm a clinical neuropsychologist by training. And it's a psychological methodology that they're using on many levels, both in discovery and at trial with the jurors. Everybody's misinterpreted it. That's a different discussion. But the point was, with lit a fire is like, I can take the number one thing going on, the most important topic in civil litigation, which is reptile theory, and I can build a system to defeat it every single time. That was really important to me. And so that's where the fire got lit, built the system. And then every stage that the reptile theory has evolved, I've followed with an evolution of my anti-reptile system. And here we are today, making a lot of noise, creating a lot of waves, and doing some really good things for our defense clients, particularly in the transportation and trucking industries.
Awesome. Well, and also, I probably should have led with this question, but for our listeners that may not be familiar with the reptile theory, on a high level, could you just break it down for them what that means, so that way you can kind of tie this all in for them?
Yeah, it's kind of confusing, and it's still misunderstood by many, which is very frustrating considering that's 2023.
Right.
But let me give you the definition of what reptile theory is from the plaintiff's perspective. The people that generate this is their marketing pitch, that they can do things at trial in a way, the way they present their story, they present their arguments, focusing on public safety, okay, safety rules that all corporations have to follow. They can activate this area of the brain called the reptile brain. And when that area of the brain is activated in the juror brain, that the juror will have no choice but to want to protect the community, protect the general public, and side with the plaintiff and award high damages to protect the community in general. That's the high level sales pitch on, in other words, we have found a way to present information to jurors that's going to activate this part of the brain, and they're going to go in the survival mode and want to protect the community from this bad company breaking all the safety rules. Okay. That's
so
their
it's playing more to the emotional side than the fact side. Is that fair? Or
that would be part of it, but almost the instinctual protective mechanism in the brain that they refer to as the reptile brain. So, as I read through their materials and broke this down, and I'm a neuropsychologist, so I'm a brain guy, I'm a brain scientist. It was kind of laughable because they butchered the neuroanatomy and neurophysiology. By the way, again, PhD neuropsychologist. There's no such thing as the reptile brain. That's a myth. That's something like 40 years. That's something like 40 years old. There's no reptile. If you go talk to a neurologist, go call your local neurologist and say, "Hey, where's the reptile brain?" They're going to laugh in your face. It's an obsolete, but boy, it sounds really cool, right? Hey, there's this reptilian part of the brain. No, there's not. Okay, there's 3 parts of the brain. None of them are reptilian in any way, shape, or form. And so their science was really, really bad, and they were just using that part as a marketing pitch. Because boy, it's a pretty sexy marketing pitch. Hey, we can put on these arguments in front of a jury, and you're going to activate this special part of the brain, and they're going to want to protect society. I mean, hell, if I was a young plaintiff attorney, I'd spend 10 grand to learn that, right? But then I broke it down and figured out that's not what is going on here. It is a very sophisticated system that has both a discovery angle where they are going after witnesses with certain types of questioning to lock them in on these safety principles, which gets the witness in a lot of trouble and increases the value of the case. So they have a very, very sophisticated attack on the defense witnesses in discovery. And then at trial, they are telling that story to the jury about the corporation, about they have violated all these safety rules, and they're putting the general public in danger. But it's certainly not activating some part of the brain. What it is, it's the perception of hypocrisy, meaning during the questioning of these witnesses, they're asking witnesses, well, your company is required to do X and your company is required to do Y, and it's all relative to these safety rules. And all the company witnesses are saying, yes, 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 yes. And now they're trapped. And then the next phase is the plaintiff attorney then goes into the case facts and says, well, your driver or your safety department or your CEO, your HR director, whoever, right? Well, they didn't do all those things that you just said were required. Therefore, you violated your own safety rules. So it's the perception of hypocrisy, meaning, yeah, we have all these policies and procedures. We have all these things in our driver manual and our safety manual and procedures. We just don't enforce them and we really don't follow them. And so there's this perception of hypocrisy from the jury, and that's what makes the jury, trust me, the jury's not having some neurocognitive realization or some part of their brain is activating like they're a robot and they want to protect the community. That's not what's really happening here. What's happening is it's a very sophisticated, coordinated system, both discovery and trial, that the defense bar was very slow to respond to, and they outmaneuvered their adversaries, and they got a lot of big verdicts.
It's similar from an underwriting perspective on the insurance side as well. You know, when underwriters look at the company policies and procedures, and it very specific. You know, our drivers, you know, can't have these violations, this many accidents, this many violations, et cetera. But then when you pull their company MVRs, it's there.
Hypocrisy.
Creates confusion.
Yeah.
And when anyone is confused about something, that's whenever all bets are off, right? So,
and the jury, it's an easy kill. It's an easy kill in front of the jurors because, again, it's in writing. It's in your policies. It's in your handbook. And then you put the handbook next to the case facts. You juxtapose those things, and you're like, well, you didn't even follow your own internal policies, your rules, your guidelines. I mean, you didn't do any of that. And then that's what led to this accident. And that's a very easy sell to a jury. So one of the things I talk about with people in the transfers is you got to get rid of that language. So one of the things I do is help clients get rid of that language. So you're not setting yourself up for disaster and litigation. You know, all the safety stuff in the materials, the internal documents of the company, it all sounds really good. It's a treasure trove for a plaintiff attorney. Smorgasbord, right? It's like a buffet for them, and they just help themselves to all this terrible language that's now going to be used against the company in litigation. So eliminating a lot of that is really step one of this process, so that you're not a very attractive target to a plaintiff attorney.
Well, you mentioned internal documents. Then there's the external exposure through social media, all advertising, whatever. So that just adds to it, I'm sure, right?
That's the second. It's equally as damaging. And so, as you saw from my presentation, so when we do these presentations to the industry, we take screenshots of their websites and we put them on the screen and we start picking on them like we're plaintiff attorneys. Like, why are you putting this on your website? And you see everybody in the crowd kind of putting their hands over their face. They don't want to be identified. But we've helped hundreds and hundreds of companies take that damaging material, which again sounds good. Hey, safety is their top priority. Okay, take that stuff off of your website, because A, no one cares. B, it's not even true. Safety is never the top priority. We could talk about that in a second. But it's only going to put you behind the eight ball in litigation. So that's the websites, any social media posts, things like that. If you have safety's number one, and that's plastered, that's painted across the side of your truck, you're in big trouble in a deposition. You're in big trouble at trial. Because again, A, that's not true. Safety isn't and never has been the top priority in any industry, much less transportation. Let's get that straight. And then number two, when you plaster it across the side of the truck or all over your website, now you're stuck with it. There's no middle ground on that. You've just raised the bar on yourself to essentially a level of perfection. You've taken out things like judgment, training, experience, circumstances, situations. That's how our lives run. That's how the world operates. Okay. And instead, you've set yourself for this. You set yourself up for what the number one thing the reptile plaintiff attorney has to accomplish is they have to establish a list of safety rules that your company must always follow. And if you agree to those rules, you've just eliminated judgment, circumstances, training, experience, right? And you're implying that, there's this rule book we have to follow, number one. Number two, if you violate the safety rule book, bad things happen. That's number two. And then number three, they go, well, let's look what happened in this case where you killed a family of four. Well, you violated these rules, therefore you're guilty. Easy, easy, easy sell to a jury, and it works. So we have to do things very early on in cases, even sometimes before a case with these policies, procedures, website language, advertising, to not set ourselves up for disaster in litigation and make life so easy for our adversary.
Yeah, And that's such great information, because to me, I talk about traditional versus intentional, right? And traditional is like riding a razor blade. You're
Yeah.
literally, if you just keep doing the same thing over and over again because the industry does it or your peers do it,
Yeah.
you're going to get ripped to shreds. So you've got to make a decision to get off that thing, so that way you can do differently, be differently, and create your own identity in this whole process.
Yeah.
Because the confusion makes you like everybody else.
Yeah, and it's so easy. It's so easy for any plaintiff attorney. It doesn't have to be a reptile plaintiff attorney, but any plaintiff attorney, when everybody's doing the same thing, then they can develop a system where they're doing the same thing, and it works every time. And so taking a deep look in the mirror, if you're a trucking company, really sitting down with an attorney, and maybe even somebody like me, and going through your stuff and say, okay, let's pretend the lawsuit was just filed, right? How would a plaintiff attorney attack us? And boy, talk about a useful exercise. Wow, very useful exercise. Then you're like doing, you're like when you want to shoot yourself in the head, like, God, why did I put that in our manual? Why did I use this language? And you know what the answer is? Because everybody else is doing it. Because everybody else is doing it. Okay, and this whole safety, safety first thing is everybody's copycats each other. Well, you're right. Redefining yourself, redefining what your values are, and really cutting back and watching what you're putting in your language is step one in this process, and highly, highly effective, because then it can't be used against you, because it's the number one place that they go to trap you. What the plaintiff's bar does.
We've listed, or we went over a few, but what would you say are the top maybe 3 to 5 common problems for a defendant in one of these situations? Like, what are the things, like, I mean, obviously we've talked about their language or their policies and procedures. You're giving the plaintiffs an all-you-can-eat buffet to take as much as they want, right? What would you say, and they don't have to be ranked, but if you could rank them, that'd be awesome. What are some common problems?
I think they're all important. The language of the internal documents and websites and advertising, that's certainly number one. Another thing, your hiring practices. That's a common area of attack. What types of people are you hiring? What types of background checks are you doing? Are you hiring people that have criminal histories? Right. And I know we have a driver shortage, and that's been a problem. Maybe you've been cutting corners, but I'd say how you're hiring people and what the criteria is and what your background checks are. I think that's really, really important, and an emphasis of attack. Number two is not having what I call a litigation crisis plan. Okay. So I live in Florida. My hurricane season starts June 1st, and it runs through. Well, it was over in October. Now we're getting November hurricanes, but it runs through the fall. My family and I have a hurricane crisis plan. Okay, so when we know, hey, we're in the path, it's coming this way, we have a preset plan. I don't have to go run into Home Depot at the last second, battling over jugs of water and pieces of plywood with my neighbors. Oh, no. I have my tools already set. I have my supplies set. We've predicted various circumstances, how we're going to handle it. I have all my extra batteries. I have my lanterns. I have all my storages of bottled water, because it's not a matter of if, it's a matter of when.
Yes.
And you can imagine some people that just moved to Florida. We had neighbors, right? They moved from New York, and the hurricane's coming. And the guy's like walking his dog. He's like, hey, so we're from New York. What do you think we should do for this hurricane? I'm like, dude, like, you got 48 hours. He's like, well, I mean, like, what do I really need? I'm like, well, what do you guys? Like, well, nothing really. I'm like, so I'm like, do you have flashlights? Do you have batteries? Do you have what? And I'm going through my list. He's like, I don't have any of that. And so he has to, hair on fire, panicking, running to the store. And when you panic, you make really bad decisions. So the point I'm trying to get across here is making a plan with your leadership, having a litigation crisis plan. So when you have that litigation filed against you, you know what to do. There is a plan. Everybody's on the same page. There's no panic, and the plan takes over. Preparation is invaluable. Okay. Related to that, another issue is having which most people have, but you'd be surprised how disorganized it actually is. It could always be better, but having an accident action plan, meaning, okay, one of our vehicles has been involved in an accident. What's our plan? We're calling our attorney immediately, right? We're getting the attorney to the accident site. We're dragging that attorney out of bed. We're getting them to the accident site. We're interviewing our driver immediately and providing emotional support, getting their story, right? All these things like that. The moment that accident happens, the clock starts ticking.
Yep.
And you don't want to let the plaintiff attorneys get the lead. Okay. And so what I see a lot, and I say this at every speech, I like football, I like sports analogies, if you're playing a football game, right? So last weekend I went to the Jacksonville Jaguars, LA Chargers game.
Oh, you were there?
I was at this crazy game, and Jacksonville's down 27-0 in the first half, and they have this miraculous comeback to win the game 31-30. Pandemonium, great time. And one of my attorney friends posted it on LinkedIn and said, hey, what a great story. Meaning, hey, if you're an attorney, even if things are going bad, never give up. That was the whole thing. Like she sounded like Jim Valvano, never give up.
Yeah.
And I replied to that as like, okay, well, how about let's not go down 27-0, damn it. Like, why are we digging this hole? Okay, you shouldn't have to come back from 27 down. You shouldn't have to. So meaning what you need to do is have crisis plans for accidents and litigation so that when something bad happens, the plan is already set. You've thought about various circumstances. You know who to call. You know who the meetings are going to be with. You know what to do. So then you're organized and making really good decisions early on. Because see, in litigation, bad decisions early come back to haunt you later. And so having a plan for that stuff is really, really important. And then finally, which is something that we have a new program out that a lot of people are utilizing, is educating your employees, ones that are most likely to be deposed. So people in your safety department, safety directors, high-level corporate people, directors of HR, educate them on litigation, educate them on reptile theory. Before I travel all over this country. I did one 2 weeks ago up in Michigan where I talked to a group of 40 people at a couple different trucking companies that came together to educate them on this is what none of them had cases. None of them. This was here's what the bad guys are doing. And I told them about the plans they needed to form. But I said, if I can educate you about this now, when bad things start happening, you're getting the ball. You get the ball at the 25-yard line, right, on a touchback. Now you got the ball in the 50 because you're ahead of the game. Education and knowledge is power. So the more you can do now before you have the panic of a lawsuit, the better position you're going to be in the end. So what I'm saying with all of this stuff is when you're unprepared, uneducated, and making poor decisions, that's what ultimately is going to kill you in the end. All of that can be fixed, Monty. All of it can be fixed right now. So then when something bad happens, you're getting the ball in the 50 instead of the 25.
You know what's interesting? You're really talking about being proactive, right? I mean, this is the difference
not
between
reactive
proactive
like everybody else on this planet.
Right. And one of the things that I notice on my side of the fence from the insurance carrier side is most trucking companies or transportation logistics companies, they may not even have a copy of their insurance policy that they purchased, right? And
Yeah.
not only, even if they do have a copy, I'll say that, they have never even looked at what their duties are in the event of a claim. So
Yeah.
when something happens, it's your next door neighbor from New York.
Yeah, they don't know what to do.
Like, yeah. And so there's a huge emphasis on, from what I do in my practice about, you've got to have a protocol in place. So,
Yes.
But that sounds like the foundation to get to your point with the litigation protocols and everything else beyond that. But you have to start somewhere. And so normally what we try to do is just say, look, your insurance isn't, I wouldn't even call it a policy. It's a contract. It's a promise to pay, right? You pay this, they'll do that. They'll do this if you pay that. And a lot of companies are breaking their contract because they're breaking promises they didn't even know they made.
Lack of organization, lack of communication with your insurer, big time problem. And the enemy takes advantage of it.
And some of it is you don't know what you don't know, a little bit of it, right? But there should be some sort of desire for growth and to get better, et cetera, which is what you're doing by coming alongside them is accelerating their development to the next level.
Yeah. I mean, that's one of the messages that I preach when I talk around the country. I have my own podcast, the Litigation Psychology Podcast. There's my plug. And yeah, it's mostly for attorneys and claims people, but I have a lot of people in the trucking industry that listen to it. They do listen to it because they want to educate themselves. Well, there you go.
Yeah. I love the rant section.
We got to have a rant. I may rant here before we're done. You never know.
If you got one right now, let's go ahead and let it go.
It's all about timing, Monty. But yeah, we're preaching proactivity. I mean, again, this is a terrible analogy. I'm just going to tell you, this is a terrible, terrible analogy, and somebody's going to get mad at me for it. But it is what it is. And again, talk about having a plan. I have a child. Well, my one son is 21. My other son's 14. He's in middle school. They have active shooter drills in middle schools now and high schools to prepare these. That's as sad as that is.
Yeah,
it's rough, but they have a plan and they go through these drills, right? And that's about as proactive as you can get. Now, I have sat down with my family and my wife, and this unfortunately does happen in our country. And I told my here's what I'm going to do if there's an active shooter. Okay, because there's three things you can do. You can run, and if you have the opportunity, that's great. You can hide. Good luck, but you can't hide, right? Or you can go after the shooter. I'm going after the shooter. I'm not going to be target practice, okay? And yeah, that's a risk. That is a risk, but that's the way I see that particular situation. Now, maybe I don't want my wife running after the shooter. Maybe I want her hiding, right? But I'm just saying me personally. Right. And what I try to talk to all these transportation clients is to say, don't be a deterrent. Don't be the target, okay? There are things you can do to put yourself in a much better situation than sit there and do nothing and be the target. And so all these things, there's so many things well before a case is filed that these companies can do to get there. And that's starting to catch on. Not as quick. I mean, I guess nothing happens as quickly as you want to. It is catching on. And then once the case is filed, now we're into a different phase, and we can talk about that. But the stuff going on now is where you have the most control. Take advantage of it and protect yourself.
Well, to relate it back to sports analogy, offense is the best defense, right?
It is. So, and a defense prevents you from winning. So,
so look, a couple other questions to lead into the next part. What kind of impact have you made specifically for truckers or trucking so far in your estimate? Can you quantify that some way?
It's really hard to quantify. what I have been told by clients, it's really hard to quantify. I think it's impossible to quantify. My clients tell me that a couple of things. Number one, they're settling cases at far cheaper, more economically palatable values because they're in such a better position as they enter negotiations for settlement or they're approaching mediation. Because the testimony, because we're training the witnesses, right? The two things I do: I train witnesses to testify effectively, and we do mock jury research to assess, vulnerabilities and assessment, assessing cases, and to be able to do those two things early in the case puts our clients in the best position to settle the case. Because trust me, you don't want to go to court unless you absolutely have to. You want to resolve the case, but they're resolving more cases at a better value because they have leverage. Mm-hmm. And the two ways they have leverage is their witnesses testify effectively at deposition, so it can't be used against them. And they do the jury research to know what their true exposure is. And with those two bits of information, make very, very, very good decisions. So that's number one, and that's the biggest thing that we're doing. Secondly, is when they are going to trial, now they're ready. Now they're ready because they've done all this upfront work. They're not entering again. They're not going into the trial down 27-0. That's how all these nuclear verdicts happen, Monty. Because they're going into the courtroom, the score's already 27-0 before they even walk in the courtroom. That's how nuclear verdicts happen. The score's not 0-0 at the start of that trial. Okay, it's not. Okay, so what we've been able to do is to level that playing field so when they are going to trial, having much, much, much more success than going in battered and bruised and weakened, okay, and just getting their clock cleaned by a very, very sophisticated plaintiff's bar. They're very, very good. You will never hear me criticize the plaintiff's bar. I build them up because they're coordinated, they're sophisticated, they're educated, they communicate very, very well. They have got their shit together. Mm-hmm. Oh, sorry about that. It's your podcast. No. I curse on my podcast all the time.
Well, hey, I want you to be your true, authentic self. So whatever that means, that's what I want. So,
okay, you got it.
So, just curious, I know you do some witness training, and that's what you're talking about.
Half of my job.
Have you ever used a dog to help with anxiety or trauma? And I'm asking that because before we hopped on, I subscribe to North Carolina Lawyers Weekly, and one of the articles was talking about using a courtroom dog to help a witness with their anxiety. I'm just curious what your thoughts are on something like that, and if that's something you've ever used.
The answer is no. The answer is no. Let's back up there. And I'm not going to quote research because I'm not terribly familiar with it, but I do know in certain populations that experience anxiety disorders, PTSD, that is one of the interventions that is known to decrease anxiety, okay, and help people cope with trauma, loss, things like that. I don't do that because even though it does work with some people, it's really inappropriate, I think, in any legal setting. And there are other far more effective ways to do that from the, psychological, clinical psychology things and interventions to use that are far more effective and are really what's needed. Because remember, what a dog does in that situation, or you see people walking around with the stress ball, right? They're doing that. There's all kinds of things that people do. That's not solving any problem. It's blunting an emotion. Okay, it's just a Band-Aid on something. The trauma still exists, right? And so what I do with many of these witnesses, so what I do with many of these witnesses, because I have a PhD in clinical psychology, is there's various therapeutic techniques that I can use with them during our witness training sessions to help accurately assess their emotional status, do some things with them to help alleviate anxiety, give them some homework and things they can do at home to further do that. And oftentimes we do tell the legal team, hey, this is the type of witness that probably needs to be involved in the health and mental health care system. They need professional help to deal with some of these issues. I want that article. I want you to send me that article.
Okay.
Because I'm interested in that. But emotion is the number one barrier to effective testimony by far. Which is why I do this so much, because that's my expertise, emotion and cognition. And emotion and cognition don't mix. It's one or the other. And so where you see a lot of these terrible mistakes being made, very expensive mistakes being made at deposition, and then depositions lead to nuclear settlements are far more prevalent than nuclear verdicts. But it's a witness not being able to control their emotions that impairs their cognition, that then impairs their communication in their answers to questions, and they make a lot of terrible mistakes. So when I'm training witnesses, there's many things I'm assessing, but one of the top things that is concerning me is, what is this person's emotional status? Okay, how do they process information, and how quickly do they get emotional, particularly in a stressful environment, which is a deposition or a courtroom, and how's that going to impact your testimony? Because if I can solve that problem, I can get rid of a lot of those mistakes that they're making, and then every one of those mistakes leads to dollar signs, right? So if we go to the end zone first and work back, right? It's the money. This is all about money, right? You don't want to lose all your money. Your insurance company doesn't want to lose all their money. The trucking company doesn't want to lose all their money. Well, how are you going to lose all your money? Well, let's take a step back to the 20-yard line. Well, bad depositions, poor witness testimony, right? That's a huge factor in how you lose that money. And so that is very, very preventable, but again, requires early intervention and not late intervention.
So what do you say to, what does it tell you about an owner of a company that embraces your strategies and what you're trying to do, ask you to come alongside them to help them through the process? What does that say to you about that leadership?
Wise, very, very wise, but also very caring. They care about their company and their employees. Let me tell you a story. So there's a company in Iowa. There's a trucking company. I'm not going to tell you who they are. I have been out there. I had a case with them, okay, and worked on this case. And they were very, very pleased with what I did. Then they hired me on another case. And we get along very, very well. Outside of those two cases, this CEO has paid me to come to his company, and ready for this? Put every single person in the company through my training because he cares about them. He cares about them. He wants them to know what the industry's up against, what all the tricks and traps are, what witnesses go through, and he wants to educate them early and give them some emotional calm that if and when the next accident happens and they may be involved and have to testify, that the CEO cares about them so much, is pre-training them to get them ready whenever it happens, and then will bring me and my team in when something does happen to support them. That makes everybody at the company feel better about the company they're working at, and about how much the CEO cares about his employees. And it gives me the best feeling in the world, because let me tell you what, next to a terrible healthcare diagnosis like cancer, or losing a close friend or family member, being sued is right up there on the same level of stress. They've measured this. You can look that up. There's plenty of research on that. Litigation stress research. Look that up. And people physiologically respond to litigation the same way they would respond to a bad healthcare diagnosis, bad news from your doctor, or bad news about a close friend or loved one. Now think about that. That's pretty intense emotion, Monty. Okay?
Yeah.
And that's a lot of stress and anxiety. And so the companies that are doing the proactive training on these levels we're talking about are very, very wise. And it's an investment into themselves, into the company, into their employees. And it's one of the smartest things that you can possibly do. And you know what? Yes, it does come at a cost. It's a drop in the bucket compared to the cost financially and emotionally of litigation.
100%. And when you're saying that, my thought was, yes, it comes at a cost, but look at everything else that they're saving, and you hit on a few of them. But
yeah,
there's a lot more that comes along with that. I mean, when you have a confident labor strategy that builds confidence in your employees, they're going to be more successful, and the company's going to be more successful.
Yeah.
So, yeah, I mean, that's great stuff. And those are the things, again, I'm relating it back to insurance. An underwriter can't see those things with the information they ask for to review to give you a rate. So
yeah,
being able to show the trainings and everything proactively that you're doing, that is where they kind of get a better look at what your identity is, instead of trying to measure your culture based on some black and white sheets of paper.
Yeah.
So they get better rates as a result.
Yeah.
So that's fantastic. And so on the flip side, right? So those are some characteristics of someone or companies that embrace your methods. How would you describe or give me some characteristics of a company that you could identify, that not the ones that don't know because they don't know, but know about this opportunity, but still decide not to engage in it and just wing it or be traditional, as we kind of said earlier? What does that look like?
Yeah. And that's the cost savings, traditional kind of cost savings model and reactive model of it's not going to happen to me. Right. I mean, it's some companies, many actually are not proactive. They're very economically driven at the moment. They're not looking to the end zone, Monty. They're thinking about now, today.
Yep.
And they don't believe in investing into protection because there's a cost to that. Okay. And maybe they'll never get sued or, whatever. Or even if there is a case, they may decide, well, I don't want to pay for, this advanced stuff because the case it's going to settle anyway. And that's exactly what the plaintiff reptile folks have done, is they know a lot of companies think like that. And those are the targets, because that's how they get up 27-0. That's how they get up 27-0, because they know you're not going to invest into the protection. It's easy money for them. It's so easy because they're going up against a defendant that's not adequately prepared. It's so easy, right? And so, yeah, you're saving money today, okay? But in the long run, it's going to cost you a lot more economically in the long run by not investing up front. And then the anxiety, the stress, it's terrible. I mean, anything in life, boy, when you're not proactively doing something, something's out there and you don't do anything on a prevention side, when it bites you, it hurts. It really, really hurts. But that's also a brain problem. The brain doesn't process. The brain's very reward based. So in other words, if I give you $50,000 and in return you give me a new sports car, my brain's like dopamine. Yeah. That's awesome. But if I give you $50,000 and you say, I'm going to protect you from the bad guys. Well,
What?
there's kind of no, like the bright, shiny object's not there. There's no dopamine. There's
Right.
no dopamine, Monty. I need
What's
my brain
the
needs
ROI,
dopamine
right?
because I don't, because even though one's a tangible object I'm getting for that 50 grand, and you're telling me, I'm going to give you 50 grand. You're telling me I'm going to say, I'm going to protect your assets. My brain just doesn't process that very well, right? That's how the human brain processes things. So it takes a lot of maturity and a lot of open-mindedness to really understand the economic risk and value of protection, right? And that's why people hate paying insurance. They hate paying insurance premiums because they're not getting the shiny object to play with. They're paying for protection in case something bad happens, and that's a big deterrent in this industry. But that type of mindset is exactly what the plaintiffs bar takes advantage of, and they know it. And ready for this, Monty? They brag about it.
Often and to everybody, right?
Yep, that's what they do.
Man, this is good stuff, and I think we need to come back for some more episodes. I'd love to have you back again.
I'd be happy to come back on. We can get into in-depth reptile stuff. We can get into nuclear. I've got hours and hours and hours and hours of material, and I have my own podcast. So I'll have you on my podcast. We talk more about this stuff. But yeah, thank you for having me. I hope your audience appreciates this. You can have any of your audience members can contact me at any time. If you go, our website is courtroomsciences.com. And if you look me up on LinkedIn, LinkedIn's probably the easiest way to find me and get a hold of me. Go to LinkedIn, put in Bill Kanasky. And I think I'm the only, because my son is Bill Kanasky the third. My father may pop up. He's in construction, but he's on his way out of that. So I should be a pretty easy find. And I'm happy to answer any questions for any of your listeners, free of charge. Just shoot me an email, whatever.
Awesome. And you have a lot of resources available from your website and everything.
Yes.
And
articles, everything we talked about, a bunch of articles, and the podcast, Litigation Psychology Podcast on Apple Tunes, Spotify, and all the major platforms.
Well, before we go, I've got something that I call the Tap 5. And it's 5 questions I'm going to ask you for, and your response can be in one word or one sentence. And we'll just kick it off. And these are totally impromptu, so I know you're not technically prepared for them, but I'm sure you'll be great.
I love it.
So the first question is, what is the worst litigation psychology advice that you've ever received or have been given?
The worst advice?
Yes.
That I've heard a client be given?
Or you specifically, like what is like maybe a strategy or a poor strategy as you're coming up through everything? Have you heard about that someone else was given?
Yeah. Particularly in the courtroom, would be to defend yourself instead of attack. Most trial attorneys, when they go out in the courtroom and they're trying the case, they kind of go into this defensive posture of, hey, we didn't do anything wrong, we're a good company, when you need to be attacking your enemy rather than defending.
So on the flip side, then, what is the best advice or strategy you've seen or you've given?
Sooner the better. Proactive, because that's how you're going to solve all of these problems that are going to end up costing you a lot of money down the road.
Awesome. So this is now we're getting a little tricky.
Okay.
Who is the greatest UNC Tar Heel athlete of all time?
Now, everybody thinks I'm going to say Michael Jordan. And I am actually not going to say Michael Jordan. Okay, I'm actually going to go in a different direction here. I'm going to say Hall of Fame NFL linebacker Lawrence Taylor. was the best
Oh.
athlete. He played 3 sports in high school. He got himself in trouble. But as far as pure athlete at the University of North Carolina, and that's a tie between him and Julius Peppers, who is another Hall of Fame football player. Michael Jordan was the best basketball player, but if you're talking best athlete, Lawrence Taylor and Julius Peppers would be the 2 freakish, incredible athletes.
For some reason, I don't know why, I thought you were going to say Mia Hamm, but
No,
yeah,
no, she was in my chemistry class. I'd do her homework for.
Oh, really?
And the other half of the soccer team, yeah.
That's awesome.
They put me in charge.
All right. So next question. What advice would you give to your teenage self if you could go back and give them some sort of preparation? What would that be?
Learn about money. Learn about how money impacts human decision making. I've learned a lot of hard lessons because I did it when I was younger. I didn't know how money worked. I'm not talking like personal investing type, but no, I'm talking like how decisions get made in this world because of money. People make really important decisions because of money. The concept of greed. I've seen people do some pretty bad things because of money. Really, really bad things. And I don't want to be that guy. And I tell my teenager, and I talk to my teenagers, you got to follow the money. You got to understand how money works, because a lot of decisions made from your employer, potential employers, the industry you work in, are most likely going to be financially based. And if you can learn how the money works, then you can make better decisions and really understand how the process works.
Good stuff. That's awesome. All right. So number 5, in your opinion, who is the greatest all-time professional wrestler? I think I know who you're going to say.
All time?
All time.
Well, I got my favorite. I got to give you 2.
Okay.
Professional wrestler, right?
Yep.
Okay. When I grew up, because I grew up in the 80s, so I grew up watching WWF.
Yep.
By far, my personal favorite, Randy Macho Man Savage.
Oh, nice.
The Macho Man. Oh, yeah. I mean, that Randy Savage was the greatest in my mind. But in reality, on paper, it's Ric Flair.
That's who I thought you were going to say.
Woo!
That's who I thought you were going to say.
Yeah, it's Ric Flair, but I grew up as a huge Macho Man because he was kind of under Flair and Hulk Hogan and stuff. I'm not a big Hulk Hogan fan. I did meet Hulk Hogan. We'll talk about that on your next episode that I'm on, because it's a hilarious story. I know we're at time, but we'll talk about Hulk. My interaction with Hulk Hogan in a hotel hallway. You'll like that story.
I'm looking forward to that one. Yeah, I'm going to take you back to WrestleMania 6. If you recall, Macho Man versus the Ultimate Warrior, career-ending match.
Yeah.
I got to say, my guy came out on top. Hope that doesn't hurt your feelings.
But
I'm a fan of just 80s wrestling, 80s, early 90s. That's the best.
It was a hell of a time, and I look back on it with fond memories.
All right, Bill, man, I definitely enjoyed it. We're going to do this again. You be well, and we'll talk soon. Thank you so much.
Thank you so much. Thank you so much for having me. I'd like to come back really soon. Let me know.
Absolutely. Thank you.
Take care.